I'll do that.
Rick Hayden will lead the Pledge of Allegiance, and Mr. Dewey will lead the...
Okay. Place your hand over your heart, follow after me. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Okay.
Okay, bow your heads, please. Lord, thank you for this day. Thank you for bringing us all here. As you say, Lord, let us all speak the truth with love today, but let us all speak the truth in any event. Amen.
Amen.
Do we have certification?
The agenda is posted.
Public comments and presentations. We're going to...
Director, at this time, I'd like to start with the Water's Life poster. Constance Winter presentation.
The school.
Good morning to everyone. Central Basin, in partnership with the Metropolitan Water District of Southern California, sponsored a poster contest for students as part of an annual recognition of Water Awareness Month. Celebrated every May throughout California, Water Awareness Month encourages wise water use, conservation, recycling, and water education. The theme for this year's poster contest was Water is Life. The original student artworks that you see in here and also in the hallway and upstairs throughout the building, they are part of a traveling art show that the posters are also featured in the 2017 Water is Life calendar as well. They'll be on display until tomorrow. This year's contest was advertised to all of the district's elementary and middle schools, as well as to extended day and after-school care sites. Students were encouraged to depict various water uses and/or wise water use at home, in school, in industry, or in business, in the environment, in agriculture, or in recreation. Teachers were then asked to send their classes 2 best posters. We did receive many fine posters. This made the process of selecting the best poster all the more difficult. However, one prize winner was selected. That prize winner is Audrey Aceituno. Audrey, if you could. Audrey, until her recent promotion, was an 8th grade student from Edwards Middle School in Whittier. She will be in the fall. She will be attending California High School. Audrey is here with her parents, Elvira and John Aceituno. If you would stand up, please. Thank you. She is also here with her teacher, Rachel Troutman from Edwards Middle School. Audrey's poster will be featured in MWD's 2018 Water is Life calendar, as well as on bottles, note cards, magnets, and other promotional items. And I'd like to show you the poster, have Audrey show you actually. If you could, just show. Thank you, and then to the audience. Thank you. Audrey's colorful poster has a simple but powerful message to save water because life depends on it. Her work will also be part of the 2018 Water is Life Traveling Art Show and will be displayed at water agencies throughout Southern California starting in January of next year. And in addition, Central Basin Director Robert Apodaca, representing Division 2, will now award Audrey with a Dell 2-in-1 tablet and laptop computer for her outstanding poster. And if we could get a few photos right over here by the backdrop, that'd be great. Thank you. Turn it around the other way.
Mr. Chairman, as you walk over, I'm going to take the opportunity to talk a little bit about this annual art contest that we have at the Metropolitan Water District. We have hundreds of submissions from cities throughout the Metropolitan Water District, and we review all of the participants within the Central Basin Water District. And every year we award a young student technology device such as this one as a result of their participation. We also make a poster every year. It's called a Water is Life poster. I'm not sure if anyone has a sample of that. Any of our staff members have a sample of that with them right now. But we produce a Water is Life poster that we give away throughout the year to the Metropolitan Water District agencies. So, as many of you know, the Central Basin Municipal Water District is one of the member agencies of the Metropolitan Water District of Southern California. And the Metropolitan Water District is responsible for maintaining all of the water infrastructure that we use to deliver water from the State Water Project and also from the Colorado River. And Central Basin is one of a number of member agencies that purchases imported water from the Metropolitan Water District. So that's a little bit about who the Metropolitan Water District is. Welcome to everyone. Thank you for coming out. And our chairman is back.
Thank you. If we could, one more time while they're... Thank you.
Okay. We have 8 speakers, I believe, Mr. So I'll call first former Councilman Bill DeWitt.
Thank you very much for considering this item. I see we have some new members here, which is always a good thing to see. And we'd hope that they would pay strict attention to this issue because it involves potentially a lot of money for the district. And we think we went through this problem in 2003 in Southgate with a very corrupt regime. Wasted a lot of taxpayers' money in the city of Southgate. And by waiving this attorney-client privilege, we were able to get back about $14 million plus or minus from people that didn't deserve to get the money to begin with. And so we're talking about a lot of money. Now, it's not as much money here, I guess, but the principle is very important on this particular issue. And we hope that the new members look at this very carefully and realize the implication in this particular case. I'm not saying necessarily to waive it in all cases, but in this case here, because this thing's been tied up, and it's really the attorneys that have bled the district of a lot of money. And it's unfortunate. It's really unfortunate because the district, the Central Basin District, which I live in, I buy water from Golden State and also from the city of Southgate. And it's important that this be run as a proper business and not have all this money sucked away by attorneys on these kind of things. So I think it's important to get this issue resolved so you can move ahead. And I welcome the new members here, some of which I know or have seen at different meetings. And hopefully we do the right thing and move on and get this issue resolved. Thank you very much.
The next speaker is Mr. Alfred Araya. Mr. Araya?
Yes. Good morning. Again, thank you for the Pledge of Allegiance and the prayer. We're all here for one reason, and that is to try to resolve these issues that go on in life where, for some reason, people have a tendency of misappropriating our funds, and it's just sad to see the way the world is. I'm pretty sure our veterans would be very upset if they see the way America is today. I just speak on behalf as an activist as well as an advocate for the people. I think it's important that we work together with transparency. These are our tax dollars. These people in our community are struggling. They're in poverty. We're being taxed to death. And from $2.75 million on up to millions of dollars that have been misappropriated. And and what they want to do is just say, oh, we'll just bill it to the taxpayers. They will go ahead and pay. But as you can see, we're all struggling. People are losing their homes. People can't pay their bills. They can't buy food. And what I'm going to say here, very simple, is this is not my first rodeo, and I know it's not your first rodeo. I know you know what's been going on, and it's been going on for a long time, and not just here, but all over the place. But what I'm trying to say here is millions of dollars are being misappropriated, and we need, as a Christian man, I try to do everything I can to be right, and not in man's eyes, but in God's eyes, because I sleep good at night, and I just pray for the people that they will also sleep good, which means they need to see that they're hurting people. It doesn't matter where you came from. This is America, and like I said, united we stand, divided we fall. I would hope that you would vote yes and expose what is going on behind the scenes. As a Bell resident, you know, I went to 95% of the court hearing, and I'm going to tell you, I've seen all the things that was done behind closed doors, and it wasn't right what they did. No one knows the actual amount of money. Millions of dollars were taken away from our little poor town called Bell, but there's a lot of other poor towns out there that also are struggling. So what I would like to say is I hope that you come to a conclusion and vote yes so that we can expose whatever's going on with this money and give it back to the people that deserve it, even if it's $5. But again, I hope you make the right decision. And again, I hope you continue to see these misappropriation of funds and really look at the people. We're all struggling. We need your help as representatives, and I just hope you take this into consideration. Enough is enough. Thank you.
Attorney Jimmy Johnson, please.
Thank you. Good morning. My name is Jimmy Johnson. I'm an attorney, and I represent the Central Basin and the Ketam plaintiff in the Ketam lawsuit that you will consider an issue on here today. I will try to do this in 3 minutes. I'm concerned with the issue of waiving the attorney-client privilege as to the creation of the trust fund. I'm talking fast. I want to beat the clock here. The Ketam lawsuit says that approximately $2,750,000 was taken from the Central Basin in 2010 to 2012. It was taken by two law firms that gave false legal advice to the Central Basin. The Ketam plaintiffs tried to get the Central Basin to act to recover the money, but for some reason the board did not pursue it. Therefore, the plaintiff, pursuant to the Ketam, the false claim statute in California, filed the action to recover the money for the Central Basin. The Central Basin elected not to intervene in the lawsuit, but remains the real party in interest. The Central Basin is the plaintiff in the lawsuit. And the purpose of the lawsuit is to recover money for the Central Basin. It would be curious if the board did not want to assist in recovering the money for the Central Basin. The defendants in the lawsuit, the two law firms and two attorneys, filed a paper with the court saying that they cannot defend themselves in the lawsuit because of the attorney-client privilege. They're saying that, and the attorney-client privilege says that communications between an attorney and a client cannot be disclosed by the attorney unless the client authorizes it. They're using that as a trick to avoid answering the lawsuit and to avoid paying the money back. Now, I'm informed that there are some misunderstandings, that there's a lot of misinformation being spread and given to the board to interfere, cause the board not to vote to waive the privilege. And I want to address 4 issues very quickly. First, I believe that board members are being told that they may have a conflict because they may be named as defendants in the lawsuit. That's simply wrong. The law in California is that a public official or a public entity or a public employee cannot be a defendant in a lawsuit under the False Claims Act. I have case law saying that. You also have the Aaron Fox investigation that was done, a very comprehensive investigation that made it clear that no board member did anything wrong or no board member was at fault. You also have a 6-year statute of limitations. These actions occurred in 2010. Even if board members were subject to liability, it's too late for any board member to be named as a defendant. Another item of misinformation that's being spread says that if the Central Basin loses the lawsuit, the Central Basin will have to pay the attorney's fees of the defendants. That also is wrong. I have a copy. The False Claim Act makes it very clear that where the Central Basin had the option to intervene in this lawsuit and chose not to do so. And the law is very clear. It's written in the statute itself that where a public entity does not intervene in a lawsuit in a False Claims Act case and the plaintiff loses a suit, only the person who pursues the suit can be made to pay attorney fees, and then only if the court determines that the case was frivolous, had no merit, and was determined and was brought for the purpose of harassment. I will leave I have a copy of the entire false claim statute, and I'll tell you this, if you turn to page 6, I'll leave this I have a copy for each of you. The relevant portion is highlighted on page 6 of the statute. Another piece of misinformation.
Excuse me. I'm sorry, but I think your time is up.
We should extend another couple of minutes, just
Okay.
let the attorney present. Just a couple of minutes.
Mr. Kevin, is it possible for Mr. Johnson to continue his comments when this item comes up for as an action item?
If the board so wishes, we can do it, but that's...
Because it sounds like there's a great deal of information that he wants to state.
Would you prefer to do that?
That's fine, whatever is, and whatever the board
We
chooses to
continue
do.
at that time, that way we...
Okay, that's fine. Thank you.
Thank you. Good idea.
Mr. Chairman, will we be able to move this item first on the agenda after
We're going to move it
okay.
to right after the public hearing on the standby.
Okay, thank you.
Mr. Geraldo Maya Cotia?
Good morning, Board. Gerardo Mayagoitia, City of Maywood. I got to say, I'm really disappointed today. 20 years plus, I've been a community activist, always trying to expose corruption in the Southeast or wherever it may be. And, I've been following everything that's been going on here at Central Basin over the last few years. I like the new reforms with the new added board members and directors that are here to kind of fix things. But I must say that this $2.75 million that was taken improperly and illegally by Sedgwick, Dietert, and Morin, and Arnold, which is very shameful. I don't understand why people who are supposed to be working for the taxpayers, not just here, but pretty much everywhere in the Southeast, always want to victimize the people. It's our money, and basically it's like you're going into our house when no one's there and you think no one's looking, and you're ripping off our money and walking out with it. Well, this time you got caught. And a lot of people are starting to get caught, pretty much everywhere in the Southeast, and I'm really glad that I'm being part of that. So today I'm just here to express my frustrations, my concerns, and I'm going to ask this board that you please waive the attorney-client privilege regarding the $2.7 million slush fund so that the people have the right to know what you did with that money. And I'm not specifically making accusations here with individuals, but obviously the former directors that were here at that time did some decisions that shouldn't have been done. What makes me wonder what they were thinking. But we know who those individuals are, and hopefully they don't get reelected again. But either way, I'm very frustrated. I am. I'm really disappointed. I take this to heart. I take it personal, when you steal money. Because I feel like you're putting a gun to me and my mother and my father and my brothers, and you're basically robbing them. Because that's what you're doing. That's what you're doing. You're robbing every single family, every single person that's here. you're robbing them and their family and their kids, because that money should be used for the taxpayers, for great things to happen in our communities, not for some attorney who's already a millionaire to take our money so they can become even richer. So either way, I am glad that there's some new changes here, and I applaud Central Basin for the direction that they're taking now. And I'm really glad to see the new directors that were appointed. And I'm also very proud of the board member and reformer, Director Vasquez, who I know has taken a stand and has been met with resistance by certain members who have paid people to fight her and come in here and protest her. And we know who you are. And it's unfortunate because in Maywood, I get the same thing. Every time we expose corruption, they come and lie about the good people. But we know who the good people are, and we stand behind you. Thank you very much.
Mr. Adolfo Varas? Is there Mr. Varas here? Adolfo Varas?
Wait just 1 second. Hi. Cool.
Good morning, everybody. My name is Adolfo, and I live in a city that I receive the Central Basin services here. I would like to start my comments with a quote from William Shakespeare. This is from Henry VI, Part 2, Act 4, Scene 2, line 73. Please don't take it out of context. The first thing we do, let's kill all the lawyers. The courageous saying those lines is the Dick the Butcher. We are here today because some greedy lawyers stole millions of dollars from the Central Basin. These greedy lawyers gave nothing back to the Central Basin in return. More of the money was given to lawyers' friends and associates. Our water rates did not go down. Maywood did not get any cleaner or clearer water. These greedy lawyers did not even win a lawsuit for us. This is just pure greed. And now these same greedy lawyers have the nerve to say they can't talk about it because of the attorney-client privilege. Let's stop the nonsense. The people in this community are not stupid. We voted you directors in office because you are our representatives. You are supposed to look out for us. You are supposed to do the right thing. Things for us. In short, you are the gatekeepers. You're supposed to keep the foxes out of the house hen. These foxy lawyers have now stolen most of the chickens and kept them all to themselves. If we vote to waive the attorney privilege, the lawyers will be forced to go into court and tell the truth about what they did. That is a good thing. Please vote the waiver for the attorney-client privilege so the secrecy, theft, and plundering of our communities can stop. We have a general manager who's paid hundreds of thousands of dollars. We have lawyers sitting here today who are paid tens of thousands of dollars per month. All of this money comes from our community and our hard work every day at our jobs. We have board members who are not paid much. They are elected by the people to rock out for the people and do the right things for the people. If you vote to waive the privilege, it will cost the General Basin nothing. It just means you're doing your job. If you vote to waive the privilege, Central Basin will cover millions of dollars in stolen money. If you vote to waive the privilege, the message will go out throughout our communities that an open and honest Central Basin is back and doing the right thing for the community. Our communities have been ripped off, abused, and taken advantage over the years by crooked politicians and greedy lawyers. Let's put an end to this. There is no good reason to continue to keep secret what the lawyers did. I am a community activist and an organizer, and I promise here today, my word under God and under oath, that those who do not do the right thing for their community will be held accountable. And at election time, using our Facebook, Instagram, Twitter, and all social medias available to us, we will spread the word, what happened here today, for the actions you guys will make today. And I urge you to do what you voted to do to be in the office, is to do the right thing for the people, by the people, within our constitutional rights. Thank you.
Commissioner Irene Barraza. Commissioner Barraza here? Barraza.
Correct. Correcto.
Mr. Chairman, ladies and gentlemen, before you speak, would you just step back a little bit from the microphone?
Absolutely.
If you go
I
too
was
close,
noticing.
I can't hear it, can't
I don't
understand
need
it.
the mic.
Very good. Okay.
That's one good thing about me. I carry my own tools. Thank you very much. Well, good morning. Just waiting for this to pop up. I was hearing Mr. Vargas. He sounds just like me. I love him. Okay, here we go. Good morning, board members. My name is Commissioner Irene Barraza. I'm Commissioner for the State Assembly, 64th District, under the Honorable Mike Gibson. I'm here today because I have a concern, and before I begin, I would like to say one thing. Honorable Board, you were elected to do the right thing. You were entrusted by the public. No, the mic doesn't work. You were entrusted by the public to represent them, to give them a sense of belonging, to be included, to be a part of. They are entrusting you with their livelihood, their family, their jobs, and their communities as well. It is my honor to come and address you today because I trust that you will make the right decision. You know, quite often people say one person cannot make a difference in such a large, complex country as ours. Well, that's not true today. Today, your board members can stand up and make a difference, a real difference, in the lives of the people that you represent. Your vote today represent the people and what will happen in the future. What you do today, we want you to vote to waive the attorney-client privilege so that the people know the truth about what happens with their money, their hard-earned money, and the slush fund. Because millions of dollars missing, we have the right to know what happened to this money. This is not a secret government, and this should not be a secret Central Basin. The court in the state of California audit found that the lawyers taking the money was illegal, period. Taking the money, the state audit ruled that millions of dollars are missing and Central Basin got nothing for it. We didn't get water, we didn't get water pipes, we didn't get equipment, trucks, or vehicles. And our water rates were not lowered. Please do something about this. If you vote against waiving the privilege, the people will know that you are working with the criminal lawyers and you're not working for the people. We need this money. We work hard for this money. We are the ones who pay for Central Basin. We have a new board, and you are supposed to be on the new board to reform, on the road of reforming with truth and honesty. Board members, I beg you today to please do the right thing. Vote to waive the privilege so that the truth can see the light of day. The government giveaways and handouts to greedy lawyers, that doesn't exist in this council, on this board. We want you to vote the right thing. We want you to do the right thing. We are counting on you to do the right thing. And if you are reachable and teachable as you are at election and campaign time, now is the time for you to show that you are reachable and that you will listen to the community as a whole, because the community that unites with you is a strong force. And you, right now, are representing the community that is screaming at you to help them because they are affected. It is your job. You took an oath. You are responsible. So all we are asking of you today is transparency and accountability for the people that you serve. The dais serves the people, and the people are crying out to you. I ask and I pray that the decision you make, that in reality you will take it forth in a positive resolution to this awful, awful situation. It is not only in your city, in Compton, we are fighting these things as well. But the community is taking action now where we've never taken action like this before. Thank you and blessings upon you.
Former Mayor Henry Gonzalez.
Hi, how are you? I'm well, thank you.
You guys have a
Yeah, there you go. Yeah, there it is, right there.
Okay, cool.
You got one or not?
Right here. Yes.
Okay. Thank you. Is it on? Can you hear me?
Yes.
Yes, sir.
My name is Henry Gonzalez, and I had the privilege of serving the community of Southgate as a mayor, vice mayor, and councilman for 27 years. I stepped down 2 years ago. All of my life as an elected official, as you, the Central Basin, took an oath to uphold the law, to uphold the laws of the city council, the ordinances, to follow the dictates of the Brown Act, to protect the money, because you are the guardians of the Treasury as an elected official. And I've always fought corruption. I've fought corruption to the point that on April the 13th of 1999, after a meeting of citing corruption in the community, I was shot in the head as I went home that day. And luckily, the good Lord was on my side. That the bullet, as they always said, I always used to say, never shoot a Mexican in the head, because we're all hard-headed. And thank God that the bullet ricocheted and didn't penetrate my skull, because I was in the hospital 1 week, and then at home a week, and then this first city council after that. I didn't even miss a city council meeting after getting shot in the back of the head. And I've always been proud of the fact that I've always fought corruption. And it's wrong. And I'm not here to really crucify elected officials or individuals, but you as board members on the Central Basin, as I did as a member of the City Council, and a lot of the speakers before me, have a responsibility, because that money belongs to your constituents, the individuals that give you the vote to put you in office, and you have a responsibility to do certain things. And I'm telling you right now, on January the 28th of 2003, we had a recall in the city of Southgate, and many of you guys remember. There was 3 councilmen recalled, along with the city attorney, the city treasurer, who was also appointed as the city, as the assistant to the city manager, and he basically ran and controlled City Hall. The only position he didn't get was the city clerk, and I truly believe if that individual would still be in office if he had controlled the city clerk, because they ran the sister of one of the members on the city council. But again, the good Lord was on our side of our constituents who took back their city, and in order to recoup the $21 million that attorneys and the council at that time gave to their cohorts and supporters that put them in office, I said, we waive the attorney-client privilege, and we recoup 16 of the 21 million that was taken away from the city and our constituents. So I'm saying to really support, along with the rest of the people that talk here today, in telling you to waive the attorney privilege, because let me tell you, you have that responsibility to try to recoup that money. And I really want to commend Letitia for taking on the thing to try to recoup that money for the Central Basin, because she's doing what she was elected to do. And I would ask you to give it deep consideration and support that request to waive attorney-client privilege, because really, it really opens up a lot of doors to you people that are processing this lawsuit. And again, it's an obligation that I truly feel that you have an obligation to do. Thank you for giving me the opportunity. I wish you nothing but the best of luck in your efforts to recoup the money as we did in the city of Southgate. Adelante, like they say. Thank you.
We have one last speaker, Director Leticia Vasquez. The attorney has a statement before.
Before you speak, Director, I'm going to indicate that on behalf of Central Basin Municipal Water District, as my client, without weighing or putting my thumb on the side of the scales of the issue that these people have been discussing, that before you address this matter during public comment, since your attorney is present and he is the sole one who is advising you with respect to this matter, that you may want to confer with him before you speak during public comment, both as to the impact it may have with respect to you and the impact it may have on any decision ultimately made by this board.
Okay, before I go on, and I thank you for that, I want to give the mayor of Montebello an opportunity to speak if he so chooses to. I know he walked in a little bit late and may not have had an opportunity to sign a speaker card, but I know he's here to support these efforts. So did you want to say anything? Mayor Jack?
Thank you, honorable board members. I'm a little under the weather and not quite prepared to speak under these circumstances, but it's very hard to speak after Mr. Gonzalez over here. And I was not part of that community in Southgate, but I did follow it very closely, and I'm very aware of how they proceeded to help truth prevail in Southgate. And right now the Central Basin here has that opportunity to do the same thing, because this isn't really the focus shouldn't be so much about greedy attorneys or recipients of this money. This is about being transparent with taxpayer dollars. So I would expect all of you to do the right thing, especially you, Mr. Chacon. Thank you very much.
She's going to address the board.
Okay, good morning, and thank you for all of the residents that are here today to support this issue. I'm really not going to comment on the issue itself, but for a little bit over 4 years ago, I ran for the Central Basin Water Board because there were a number of challenges and a lot of controversy with respect to contracting practices and so forth and so on. So I ran on a platform to reform the Central Basin. Over the past 4 years, this board has spent a lot of time, our staff has spent a lot of their time, a lot of energy, making sure that we had this place audited, that there was an investigation that was done into this trust fund, which this board approved. We hired a law firm to conduct an investigation into this trust fund. The investigation turned up that what the lawyers did was improper. The state came in for about 6 months and spent hundreds of hours at this agency sifting through documents and gave us about 32 recommendations about that had to do with administrative things that we needed to change with respect to how we were spending our money, with respect to the stipends that the directors were receiving. And so About 2 months ago, last year, there was also a piece of legislation that was introduced and passed by Assemblywoman Cristina Garcia to help to reform the board. That legislation required that we add 3 new directors to this board. We have the 3 new directors here, Mr. Bill Getney, who represents one of the private water companies, Mr. John Oscui, who represents the cities that we sell water to, and he's the assistant city manager in the city of Downey, and also Mr. Mark Grajeda, who is the general manager of a small water agency similar to Central Basin in the city of Pico Rivera. So this is the first time that they get an opportunity to weigh in on this issue. I simply want to say that it's been a long 4 years. We have fought to reform this agency, and really this is just the cherry on top. I'm very proud of the work that we have done to change the culture and to change the way that this organization has run. And this decision will help us move in the direction of recovering the money. So without really getting into more specifics about the case is, again, it's public record. It has been filed with the courts, and I will do my job as a member of this community, and will keep you informed of what happens. But in the coming months, we're hoping that the decision that is made today, that we're able to move forward with this lawsuit to recover over $2.7 million that were improperly taken by the lawyers, the former lawyers that represented this agency. So, thank you.
Yeah, Leticia, can you ask item 20 to be moved up, please?
We're going to do that right now. It's going to be handled next.
Okay. Thank you.
In light of the crowded circumstances here, I'd recommend that we move item 20 up to the very front of the agenda right now, prior to handling anything else. So if that's okay with the board, we'll go to item 20. Is that all right?
And let the record reflect that Director Vasquez, who is the relator in that case, has left the dais and will not be participating during the presentation by the general manager or the discussion by the board of directors.
Before we go forward, do we need to make a motion to reorganize the agenda?
No, we don't.
No? Okay.
Thank you. The reason that this is on the agenda now is that we have a new board. We have 4 new members, as has been mentioned today. We also have a fairly unique situation in that we have only 2 lawsuits left, both of which have to do with AB 1794, both of which will be disposed of this summer rather quickly in August. The only other issue remaining is the Ketam lawsuit of Director Vasquez. And we thought it would be good that the new directors get any questions they have on it answered. They've been briefed before in closed session by the attorneys, but have a discussion on whether or not they want to proceed with it and in what form. The board action as it's written on there when we get to it is a little convoluted, so when we get to the board action, let me explain why we have it the way it is. But right now the question is, on the Ketam lawsuit, is there any information or questions that the directors have to fully understand it? We have the attorney for the plaintiff here. We have our attorney here to answer any questions. And is any questions any of the directors have?
I would like Mr. Johnson to finish with his comments, and then based on that, I would probably have some comments to our attorney.
Yeah.
Unless he was done with his comments, I don't know.
Okay. You can have as much time as you need. Yeah. You can take my yeah, sure. Don't give it to him. I'd like to give a copy of that to each one of the directors.
I'm asking the secretary to distribute to each of you a copy of the statute that is the basis of the Ketam lawsuit. referred to it during my initial comments. I just want to put one of these false statements that's been given to you. If each of you would turn to page 6 of the statute, there's a highlighted portion that deals with the issue of payment of attorney's fees to the defendants if they win the lawsuit. And remember that the Central Basin did not intervene in this lawsuit, so this highlighted portion is the section that is applicable. And it makes it very clear that if the public entity does not intervene and take over a false claims lawsuit, and the plaintiff loses the lawsuit, public entity is not liable in any way for attorney's fees. So if you're being told that if the Ketam plaintiff loses the lawsuit, you may be stuck with a bill to pay the attorney's fees of the defendants, that is just false, and it's being told to you by someone, I guess, who's just trying to scare you. Also, I'm informed another thing that some directors are being told is that even if you win the suit, the defendants can then sue the Central Basin, and the Central Basin will have to pay money to the defendants. Well, that's really absurd. I mean, the idea of that makes no sense. Just let me give you an analogy. Let's assume you work hard, you buy a house. You own the house, you have a nice house, and there's a restaurant nearby, and there's a party at the restaurant, and they're drinking at the party, and one of the party goers leaves the restaurant, and he's driving down the street, and he loses control. He's driving drunk, and he runs into your house and does thousands of dollars in damage to the house. And you sue the drunk driver to recover for the damage done to your house, and you win. Do you think it would be possible for the drunk driver, the wrongdoer, to then sue you because you won the lawsuit? The idea of that makes no sense. So if you're being told that if you win the lawsuit, you might still have to pay money to the defendants, that is ridiculous. There's no way that can happen. Another thing I'm informed that you're told, some of you are being told, is that, well, if you continue to sue these lawyers, the word will get around and you will not be able to hire lawyers. The Central Basin will be lawyerless. You won't be able to hire lawyers. Well, there are over 150,000 lawyers active in the state of California. Most of them are in Southern California. If you put out a request for proposals, that Central Basin is seeking new representation, legal representation, you'd have lawyers lined up from here to downtown Los Angeles trying to get you as a client. So there's no way that is going to happen. Now, the waiver is important to the Central Basin if you believe that recovering, and the recovery, if the plaintiff wins, the recovery would be more than the amount that was taken from the Central Basin. This is a statute that has a treble damages provision. The complaint alleges that $2,750,000 was taken from the Central Basin. The statute says that if we win, then the defendants have to pay 3 times that much, 3 times that amount, plus some civil penalties. The total recovery for the Central Basin could be approximately $8 million. So there's a lot at stake for the Central Basin. It's important that you understand that even though the Central Basin did not intervene in the lawsuit, the Central Basin is still the real party in interest. It is the Central Basin's lawsuit. It is the Central Basin's claim and cause of action. The waiver of the attorney-client privilege will assist in getting the money back for the Central Basin. What it will do most immediately is make moot an issue that is now before the Court of Appeal. This lawsuit, the money was taken between 2010 and 2012. The lawsuit was filed in 2013. We are now in midway through 2017, and the lawsuit is still in the very beginning stages. Why? Because the defendants have been successful in delaying and installing. The first thing one of the defendants did, one of the defendant law firms did, was file a motion with the trial court demanding that the case be sent to arbitration, that the case be taken out of the court and sent into arbitration. We opposed that motion. We won. The trial court ruled in our favor and determined properly that the case was not obligated to be sent into arbitration, even though the law firm had an arbitration clause in its agreement, its retainer agreement with the Central Basin. Well, what did the defendants do? They appealed that, which they were permitted to do, to the Court of Appeal. That appeal was in the Court of Appeal for a year and a half. We won that in the Court of Appeal. The Court of Appeal ruled that the trial court was correct, that the case did not have to be sent to arbitration. But it delayed the case for a year and a half. So then the defendants file a paper telling the court, well, we cannot defend this case because of the attorney-client privilege. We cannot disclose in communications between us and the Central Basin because of the attorney-client privilege. And then the Central Basin voted to waive the attorney-client privilege. Well, then the defendants come back to court and they tell the court, well, that vote was invalid. One of the directors who voted had a conflict of interest. The trial court looked at it and ruled that there was no conflict of interest and ruled that the vote was valid. But what did the defendants do? They didn't then appeal that to the Court of Appeal. That appeal was filed in June of 2016, and it's still in the Court of Appeal, undecided. So they've delayed the case another year. So that's 2.5 years issues have been in the Court of Appeal. What a vote to waive the attorney-client privilege would do, a new vote, it would make that issue moot, and we could get on with the litigation and resolve this issue. It would allow the suit to continue. It would assist the Central Basin in getting its money back. And you need to understand that this is being done with no cost to the Central Basin, and you're taking no risk. I mean, so there's no reason not to do it. And keep in mind two things. The suit is for the benefit of the Central Basin to recover money taken from the Central Basin. The suit is in the name of the Central Basin. And two, the suit is in the Central Basin's best interest to win the suit and to recover the money. That's all I have to say. I'd be happy to answer questions if you have any. Yes.
Why isn't Pacifica mentioned in the lawsuit?
Why what?
Why isn't Pacifica mentioned in the lawsuit? It's my understanding they were not involved in creation of the trust fund. That's the subject of the lawsuit. Okay, I'm just asking because Mr. Apodaca, his fiancée, wife, whatever she is related to Pacifica. So I want to know if that's one of the reasons why they are not mentioned in this lawsuit.
No.
Mr. Chairman, the question was asked and answered by the speaker. I think we need to move on.
Well, I think he's still going to answer something else.
The lawsuit deals with the creation of this trust fund. And it's my understanding, and based on my knowledge, the Pacific had nothing to do with it. This was something that was done by the attorneys who represented the Central Basin during that period of time, from 2010 to 2012.
They were here at the time.
Well, they may have been here. I'm just telling you, it's my understanding they had nothing to do with the creation of the trust fund. That is the focus of the lawsuit.
Okay. I got another question.
Okay.
why were the people that discovered the slush fund fired by my colleagues?
I'm an attorney representing the Central Basin and the Keaton plaintiff in this lawsuit. I have no idea. I cannot tell you why somebody was fired or hired.
Your client was one of the ones that fired the people that discovered the slush fund. I brought it out in the open. After that, it was a closed session matter.
Again, Mr. Chairman, this is not a question on this. This is not a question to this particular attorney and this gentleman. We're here to discuss whether or not this board is going to take action to vote to waive our attorney-client privilege or not to do that. That's what we're here to do. And if Mr. Johnson's done, I have some questions of our attorney.
Do you have any more questions for Mr. Johnson for anybody?
I don't.
I just wanted to make it clear on the record that 2 directors voted to fire the people that discovered the slush fund.
Okay. All right. Thank you very much. Thank you, Mr. Jones. Yes.
Director Ojeda, you had a question for our attorney?
Yes. I don't know if you can answer it, Mr. Tallman, but will there be a cost to Central Basin, and is there risk involved?
Members of the board, the district is, as I understand it, is incurring a limited expense as long as this lawsuit continues, because there is another law firm that had been hired some time ago to monitor this particular lawsuit. That service is being provided by an attorney by the name of Michael Zwiebach of, I think, Arrington Fox.
No, he's now with Alston-Berg, but that's a minor contract.
Let me clarify my question. I don't think Mr. Johnson meant that type of cost. I think he meant a direct cost as to this particular lawsuit going forward.
I have not looked at all the papers in this case because it's not something that our firm has been retained to do, but I think any potential liability of the district is extremely remote.
And I might mention that when the district chose not to intervene in the lawsuit, the district committed to cooperate with any legal proceeding that may still commence, including assisting the plaintiff, the court, witnesses of the defendant as required or appropriate. So we do have costs to provide information, etc., but we do that anyway under freedom of information.
Okay. I would like to add one other comment regarding the status of this. If the end result is that the information can be provided by the attorneys to the court, the one view you've heard is that the disclosing of that information is going to assist the plaintiff. I don't know what information is going to be provided, and we don't know whether or not the defendants do have an explanation that would be lawful, that would allow them to escape liability. But what it would do, if ultimately the attorney-client privilege is waived, as it was done on October 9th, 2014, then at least the court can hear all the information from both sides.
I believe that's exactly what the Superior Court judge said in July 23rd, 2014. He said, I think if they wanted to clear the air, just waive and get it out there. And maybe there's an explanation for this. I have no idea. There's no way I can tell. In other words, his recommendation was to waive. That was.
So, Chair. So I have a question, Kevin. There was a gentleman, I believe it was the second gentleman that spoke, wanted us to approve. But would you talk about the motion? The recommended motion here is consider rescinding the prior action of October 9, 2014, in which the attorney-client privilege was waived. If we approve that, then we're not approving, we're not doing what most of the individuals here are asking us to do. So would you just discuss that? So
let me explain. We have already had an approval. It was a 3-0 vote that the board took to waive the attorney-client privilege. So it's on the record now that this board has waived attorney-client privilege. If we go back and vote to waive it again, and for some reason, either it fails because we don't have a quorum, somebody abstains, says they're too new, we don't get the 5 votes, then it would essentially rescind the former waiver. So what we're doing right now is making a motion to cancel the former waiver. We don't, in that case there, unless it gets 5 votes to cancel, in which case it's the will of the board, the prior motion stands, even if it fails for lack of a quorum. The problem we have is that with a 7-person board and 4 of the members being no, anyone may decide to abstain, we may not get a quorum for it. So this is a way to protect the prior decision. I realize it's complicated, and I know Director Vasquez wasn't particularly happy with the way it was worded, but I believe that's the best way to preserve the prior decision to waive the privilege, and that's why we have it stated like that. I believe that's what the... Now, if you want to state it the other way, that's fine. This is a board decision as to how you want to state it, and, again, it's a public meeting, and people live with the consequences, but I've given you my best recommendation on how to preserve the fire waiver regardless how the vote goes today.
General Manager Hunt, you mentioned the vote was 3-0 in 2014.
Yes.
Were there members absent?
Yes, sir.
What were the votes?
I'm sorry, Director Hawkins and Chacon were absent.
No, excuse me, we were not absent. We were here, but we walked off the diocese because we didn't want any part of it.
Okay, so they did not choose to vote on it. They walked off the diocese. So the remaining were Director Apodaca, Director Roybal, and Director Vasquez.
Okay. The allegation is that obviously there are millions of dollars missing to the tune of about $2.7 million. Are there $2.7 million missing?
No, I think missing is the wrong word. They may have been misappropriated, may have been used in the wrong thing, but I think that we know where the money went. It went to pay attorneys, it went to pay engineering consultants, it went to pay lobbyists and bills and stuff. So it's not a question of missing. That would have turned up in an audit. It would have been an easy case to do. This was a case of...
findings?
I've never read the audits back then. Yeah.
Kevin,
Yeah.
you just said there was engineers involved in this thing. Why is Pacifica not mentioned in the lawsuit?
First of all, I have no idea why Pacifica is not mentioned, other than they were probably a sub to the prime. They weren't the prime thing, or they weren't involved, as Mr. Johnson said, they weren't involved in the thing. I have no idea.
They were the main engineers here.
Again, I have no idea. They were not the engineer record on this project that was done in secret.
It smells fishy to me.
I have no comment.
General Manager Hunt, was there a document, an EIR prepared?
Yes, there was a document.
Does that EIR have a value that is close to what has been said it is the value of the EIR report?
The work that was done, in other words, there was a tremendous amount of work done in terms of hydrogeology and water resources and then environmental planning. I've read the reports just for engineering interest. I've talked to the people involved back then. There was a considerable amount of work done. It wasn't that the money was frivoled away. I have not seen any work product from attorneys or lobbyists or stuff that were paid. I've just seen the engineering work product.
Was the EIR the same document that formed the basis of a series of discussions in the form of workshops conducted by the Central Basin with the water purveyors, I wanted to say perhaps 2 or 3 years ago, to discuss the issue of storage?
I have no idea. It was before my time.
Well, I recall there was a series of meetings. Purveyors participated in those meetings, the workshops with the district, and ultimately that all went away when legislation supported by WRD was passed and put into the law that did not allow Central Basin to store water. So that issue kind of resolved itself in a way, did it?
Yes, it did.
Okay. I have a question for our attorney, or perhaps Mr. Johnson. You indicated, Mr. Johnson, that if there is any recovery, it could be to the tune of 3 times as much as the value of the claim, $2.7 million.
That's correct.
Okay.
That's correct.
Could you also tell me or our attorney, please, how is the distribution of the funds? How is it going to happen? Who gets what?
All the money belongs to the Central Basin. If the plaintiff wins, the court if it is determined that the Ketam plaintiff is an employee, the court can then give a portion of it to the plaintiff.
So a portion goes directly to the plaintiff?
If the court determines that the plaintiff deserves it, correct? Nothing goes directly to the plaintiff.
Right.
If the jury comes back with a verdict and award, it's all the Central Basin money.
Right. And it is a certain percentage, or is it at the pleasure of the court to decide?
The court can determine a percentage, I believe it's between 0 and 33%.
So if it's 3 times as much as the 2.7, that's $8 million, and 30% of $8 million is roughly 2.4, potentially could go to the claimant.
Correct.
And the court can decide that?
Yes. And the court could decide to give 0%. But even if that happened, that Central Basin would recover because of the plaintiff, it would have much more. It would have over $5 million when 2.75 was taken.
Thank you. I have a question. There was a reference to a trust fund having been established. Was a trust fund ever established?
Yes, that's the subject of the lawsuit.
And that was by the vote of this board?
The creation,
not this board, prior board.
The creation of the trust fund and the dispensing of money from the trust fund.
Right, and it was a 5-0 vote of the board at that time?
I don't know.
Thank you.
Mr. Hunt, I have a question, just kind of summing up from my own understanding. We had a decision. This is done in closed session. We went forward. We prepared work product. And that work product ostensibly was an EIR or something to cover CEQA. That work product was made available. There may have been workshops or other work done around that, but then it was overcome by events because of the California legislature when they said we cannot store groundwater. Is that pretty much where we're at with this? Very quickly, 30
Very quick summary. I mean, there was a period in between there where what was hidden became public, and there was a lot of turmoil. And then that's, I think, what led to the legislation. But again, I wasn't directly involved at that time. I was working elsewhere.
So basically, though, we did go into an agreement of some kind. We had work product prepared. There was effort around that. I don't know, how effective that work product was. I've heard different things. But at the end of the day, we have questions now as a board as to whether or not that was a valid decision and what we should do going forward. And so that's just what I wanted to clarify in my own mind.
The question whether it was illegal, the trust fund was set up legally, whether it was appropriate to be done in closed session, etc.
Okay. All right, thank you.
But these questions have been addressed by the state audit, right?
Yeah, the audit did spend a couple of pages on this.
Right. And that's why we're doing what we're doing now, because there is now a framework for how the board can make its decisions, procurements and all of those items that was discussed in the state audit.
Yeah, no, we have fully implemented the state audit. The reason we're here today is frankly the plaintiff requested it.
Yeah, okay.
One clarifying thing I'd like to make, Mr. President. In response to one of the questions that was raised about the division of the proceeds, Mr. Johnson has provided each of you with a copy of the statute. If you go to that same page, number 6, that he handed out, at the very top, subparagraph 3, says if the state or political subdivision does not proceed with an action under subdivision C, the Ketam plaintiff shall, subject to paragraphs 4 and 5, receive an amount that the court decides is reasonable for collecting the civil penalty and damages on behalf of the government. The amount shall be not less than 25% and not more than 50% of the proceeds of the action or settlement, and shall be paid out of these proceeds. Number 4, just below it, says, if the action is one provided for under paragraph 4 of subdivision B, the present or former employee of the state or political subdivision is not entitled to any minimum guaranteed recovery from the proceeds. The court, however, may award the qui tam plaintiff those sums from the proceeds as it considers appropriate, but in no case more than 33% of the proceeds if the state or political subdivision goes forth with the action, or 50% if the state or political subdivision declines to go forth, taking into account the significance of the information, the role of the qui tam plaintiff in advancing the case to litigation, and the scope of and response to the employee's attempts to report and gain recovery of the falsely claimed funds through official channels. The question that this last provision doesn't answer on its face is whether an elected official, an elected member of the board, would be considered by the court as an employee under that section. I do not know the answer to that question.
Thank you.
So, Mr. Chair, Kevin, can you tell us again, based on the recommendation motion, tell us again how it was written, and, well, it says consider rescinding the prior action of October 9, 2014, in which the attorney-client privilege was waived. So someone would have to make a motion on that, there'd have to be a second, and then if that motion failed, does the action taken on October 9, 2014 stand?
That's right. And then if that prior motion, again, this is the legal theory and the attorneys can weigh in, if the prior motion was found to be invalid for any reason, they would look to this board, and this board had ordered declined to overturn it, and therefore it would stand. That's the theory, I believe. Attorney Pellman may want to...
Yes, it's really twofold as to why it's written this way. One is to consider whether this board, as currently constituted with 4 new members, wants to rescind what was done previously, and that is to not have the attorney-client privilege waived, but also by having it phrased this way, it relates back in time. Another word that could have been included in here was to ratify what was done in October of 2014. So it depends on what the board wants to do, whether you want it to be waived or not waived, but also are you taking it back in time to ratify what was done back in 2014?
So, Mr. Pullman, for the benefit of the audience and my benefit, let's simplify. What is a no vote going to mean, and what is a yes vote is going to mean?
Well, if
there's a recommended action in here.
The recommended action doesn't say rescind, it says consider rescinding. If the motion is made to rescind the prior action of October 9, 2014, then, and if that motion fails, then that October 9th, 2014 decision stands from that point forward with the attorney-client privilege waived.
And I might interject. Attorney Johnson is recommending that we take a positive vote to again waive the attorney-client privilege.
To reaffirm the previous vote.
So it's clear.
Yeah.
I mean, I can tell by the questions here, and I think anybody looking at it would wonder, just as you asked, what does a no vote mean, what does a yes vote mean? I think it's just be a lot simpler.
Yeah. And you understand, sir, that if the yes vote, the way you want to do it, fails just for lack of votes because someone abstains, it still cancels out the prior motion.
Also, if it doesn't refer to the October 9, 2014, the waiver arguably runs from today as opposed to October 9, 2014.
But whichever way, again, if you have a suggestion you're going to make.
Have it run from the day, really. vote to reaffirm or ratify the waiver of, you can pose it that way, to reaffirm or ratify the waiver that was given in October 2014. That can be, the issue is very clear. Doesn't require any explanation.
Kevin, just so I'm clear here, we're probably here because what the board did back then was not right. There should have been a conflict of interest with Brown Act violation, maybe. Because one of the directors who voted on the issue should not have voted on the issue. That's why we're probably here again today.
No, we're here, the trial court's determined.
Oh, hold on, I'm asking the...
I'm not an attorney, so I have no idea what was appropriate or not at the time. We're here because we were requested to put this on the agenda.
Okay, so let me ask our attorney over here, because I'm pretty sure I'll probably get a better answer. The vote that was taken back then, since one of the directors possibly stands to make money, was it legal or not legal?
I'm going to defer to what happened with the trial court judge. The trial court judge made a determination that there was not a conflict of interest with respect to that vote.
Okay, so why are we back here again?
Back here again to clarify the status of it with 4 new members of the board having the opportunity to weigh in on this issue.
I think I addressed that during my comments. The case has been stalled for 2.5 years, taking issues to the Court of Appeal. This issue is now in the Court of Appeal, and it's been there for a year. A new vote to waive will make it moot, and this takes it out of the Court of Appeal, and we can move forward with the lawsuit.
And I understand what you're saying, but there was already a vote taken. So it doesn't make sense to me why we're back here again.
That vote is before the Court of Appeal, and it's been held up, it's been there for a year.
Okay, so why is Director Vasquez not in the room?
So the issue doesn't even arise again.
I'm just curious why she had to step out.
There was a question as to whether or not there was a conflict.
It eliminates the issue.
It removes that issue.
Okay.
Mr. Chair, based on the fact that Mr. Pellman, again, would you say that Director Chacon asked the question about the original action taken was found by the appellate court as being, or by the trial court
judge,
as being
not a violation.
Not a violation of conflict of interest. Mr. Chair, I make the motion to ratify.
He makes the motion. Let me ask a question before you make a motion. My understanding is we spent about $300,000, $400,000 on this case, and we're not a party to it. If this makes us a party to it, or if this makes it, are we going to get a guarantee that Central Basin will not have to pay any more money?
First of all, the money you spent before was, I believe, for the investigation that Aaron Funks did.
Yeah.
That was you. Second,
that's our money still that we
spent. Second, nothing we do today should change our position, correct me if I'm wrong, but nothing we do today will change our position, being liable for any of the costs of the prosecution going forward, other than providing information.
That's what we were told in the very beginning, that this wouldn't cost us anything, and we've already spent close to $400,000.
But you chose to do that.
Get some kind of guarantee that this is over.
I have no idea what guarantee they can give you.
It's not costing the Central Basin a penny.
We've already spent $400,000.
That was not for the lawsuit. That was an investigation into the trust fund. The lawsuit hadn't been filed.
That's our money that we spent.
Since the lawsuit has been filed, it hasn't cost the Central Basin one dime.
Well, then I'd like to get our $400,000 back because we've spent it.
Point of clarification. I'm sorry, Mr. Johnson. Point of clarification. I did ask specifically with regard to the statement about no cost and no risk. Our attorney, Mr. Pellman, has stated that other than minor costs, a significant cost is not on the forefront. We're not involved in this lawsuit, sir.
That's true.
So, again, my motion then is to...
I'm sorry. Let me just, since the issue of spending $300,000 or $400,000 was brought up, there must have been a decision by the board to spend money to investigate the issues surrounding the establishment of the trust fund. Is that correct?
That's correct.
And that money must have been spent 4 or 5 years ago?
About 4 years ago. It was 2013, I believe.
So again, it was a decision by the board at that time to spend that
I've
money.
read I wasn't here at that time, but I've read the documents. And they authorized the Aaron Fox study, and they did a study and came up with conclusions, which is actually part of the basis of the lawsuit.
Thank you.
I'm not sure if this would be appropriate. I represent one of the law firm defendants that used to represent the
Excuse me, I need...
And I just want to be available. I feel like certain of the things that I've heard are not entirely accurate, and so...
Would you please state your name?
Sure, my name is Bethany Kristovich, and I represent one of the law firms that is a defendant in this action, and I've been on the other side of many of the issues that you've heard about from Mr. Johnson. And I just wanted to clarify a few points. First of all, if this lawsuit does proceed, the Central Basin would not be a party to the lawsuit, but it would be involved in the lawsuit. In other words, many of the directors who participated in the decision-making would be deposed. You would have to produce documents. You would have to respond to discovery requests. So the notion that Central Basin, while not technically a party, would have no involvement, in my view, and again, I represent one of the law firm defendants, would be inaccurate.
I have a question.
Sure.
Letitia Vasquez's husband approached me in Contract Cities, and he said that, you are not part of the lawsuit, so we would be part of the lawsuit.
So this is a technical legal distinction, and let me just see if I can. You would not be a party to the lawsuit other than it being pursued in the name of Central Basin. Central Basin declined to intervene and would not officially be a party. That said, that does not mean there would be no involvement by the Central Basin required in the lawsuit. In other words, we could issue discovery requests, subpoenas for depositions, documents, things of the like. So what you have been told that you would not be a party to the lawsuit, that may be technically true, but you should not take that to mean that the Central Basin would have no involvement in the lawsuit or would not have to spend, for example, money on attorneys or other things. Okay. So the other thing that I think people should be mentioned is I feel like there's this pie in the sky, millions and millions of dollars. Remember, the money that was expended, this is not money that went to lawyers. This is money that went to an EIR and CEQA action that the Central Basin approved in due course. I think you should, when you're being promised big pie in the sky recoveries, you should remember that the notion of getting back money that has been paid out the door as a result of a valid, binding 5-0 vote by the board is I don't think people, you should take that, I think, with a degree of skepticism, which I'm sure all of you are capable of delivering. And I'm happy to answer any questions. For example, the notion that the trial court found no conflict, that's true. The trial court found no conflict, but the Court of Appeal then agreed to hear a writ proceeding on it. They do that, I think the number is something like less than 5%, around 2% of cases. They heard oral argument in May, and I think they were very skeptical. Again, we don't have a decision yet of Mr. Johnson's position.
This is not a court of law. This case is in a court of law, so let's not debate it here.
I agree.
just want to give you some time to answer the question.
Okay. So if anyone has any questions, we're happy to get this. Okay.
Director Verhey, you had a motion?
Yes. So based on the questions and comments, everything I've heard, then I make the motion to, I think, to ratify the action taken by the board on October 9th, 2014, in which the attorney-client privilege was waived. I make that motion.
So this is a different motion. A yes vote would affirm the prior decision to waive the privilege.
That is correct, sir.
So this is a substitute motion.
Substitute.
It requires a...
Second.
Okay, second.
Is there any discussion?
Yes. Once again, we have not got information from our attorneys to saying yes, we should go forward, or no, we shouldn't go forward because we're going to open up a can of worms here. I feel that we're not getting right representation from our attorneys, or unless everybody else got it, but I didn't get it.
I believe that this is a board decision, not an attorney decision. The attorneys have given us ample legal information for you folks to make the decision. If you have any questions, please ask them.
Call for the question. Any roll call?
Director Osculi?
Yes.
Director Vasquez? Director Grajeda?
Yes.
Director Chacon?
No.
Director Gedney?
Yes.
Director Hawkins?
I'm going to abstain.
Director Aceituno?
Yes.
President Apodaca?
Yes.
Celia, I'd like to make that an
Just to clarify, this is
We want to note for the record that Director Chacon changed his vote to an abstention. That's just for the record.
Directors, I know could we take a brief 5-minute recess for potty break, whatever, and then restart the board meeting and complete our agenda? We have some items that have to be done. Yeah. The attorney would like to.
Yeah, you would need to make a decision to go into closed session as an item that had arisen since the posting of the agenda. We have some information to report regarding the Ronald Belke versus Central Basin lawsuit. So someone should make a motion to make a finding that the need to take action arose since the posting of the agenda.
I'll make that motion based on the way you read it.
Okay, and then take a vote on that.
Director Osculi?
Yes.
Director Vasquez? Yes. Director Grajeda?
Yes.
Director Chacon?
I couldn't really hear him. Can you
This
repeat
is
that
to add a matter to closed session, the Belke item.
again? Okay, yes.
Director Gedney?
Yes.
Director Hawkins?
Okay, I don't see a closed session
No,
on
we're
here.
going to add it on, sir.
The information has just come to light
Just
during the
come to
course
light,
of the
it's
meeting.
Okay, so we're not adding on to it, we're creating a closed session.
Right.
Okay, yes.
Director Aceituno?
Yes.
President Apodaca?
Yes.
Okay. The next item before I'd like to skip the staff metropolitan report. If the metropolitan directors have anything they'd like to report.
Not at the moment.
I have nothing.
Okay, we will mail out the staff report. And then the consent calendar. I move it.
Second?
Director Osculi?
Yes?
Director Vasquez?
Yes?
Director Grajeda?
Yes.
Director Chacon?
I got one question before I even make that motion. Since we're going to go into closed session, do we have anybody out here that we need to deal with before we go into closed session?
We're not going into closed session to the end of the...
Oh, okay. All right, yeah.
Thank you, sir.
Director Gedney?
Yes.
Director Hawkins?
Yes.
Director Aceituno?
Yes.
President Apodaca?
Okay, consent. Next, we have a public hearing. Director Apodaca, do you have a...
Okay. Did we just pass the finance stuff? Cecilia, I want to abstain on the one item, on the Nossaman billing.
So just for the record, Director Chacon would like to abstain on the demands with respect to any Nossaman billings.
Does that mean he's abstaining on payment to the attorney for being here at this meeting also?
Anything that has to do with any Nossaman billing.
It's just specific to what's listed in your demands. If there's anything...
So does that include the meetings where the attorney attends the board meetings?
If it's listed in the billings, it would be in...
Is that a yes or
Yes.
no? So he
Yes.
does not want to pay the attorney for being at the board meeting?
He does not want to pay the attorney, period.
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 And I don't want to bring up the issue here because, we're out here in public, but if you want to hear about it, I'll let you know in closed session.
Okay, Director Apodaca, could you begin the public hearing?
This is a public hearing to receive comments on the proposed Central Basin and MWD recycled water parcel charges. Today, the board will receive comments and consider approval of these charges. A notice of this hearing and the board's intent to approve the Central Basin Water District recycled water parcel charge was published in a daily newspaper of general circulation in the geographical area of proposed district as prescribed by law. The order of presentation of testimony at the hearing will be district staff, public agencies, and other interested agencies and groups and individuals. Anyone so desiring will be heard. If you have not filled out one of the speaker card located in the back of the boardroom, please raise your hand and will be provided to you. It will be appreciated in all persons appearing before the board today leave written copies of their testimony if prepared. The board will be considered all testimony. However, in the interest of time, it is requested that all repetitive and redundant statements be avoided. May I have a motion to open the public hearing?
So moved.
Second.
Director Oscuri?
Yes.
Director Vasquez?
Yes.
Director Grajeda?
Yes.
Director Chacon?
Yes.
Director Gedney?
Yes.
Director Hawkins?
Yes.
Director Aceituno?
Yes.
President Apodaca?
Yes. The hearing is now open. Presentations, number one, district staff.
Good afternoon, directors. I'll be presenting to this item to you. This is the last step in completing our standby charge for the 2017-18 fiscal year. The standby charge is a $10 parcel charge with a maximum of $20 that goes against any parcel within the Central Basin service area. It represents roughly $3.2 million worth of revenue, which gets applied to our bonds for our recycled water system currently. Looking at the parcel charge as a whole, there's 3 items, 2 of them which you've already completed. Those included the engineering report and the adoption of the resolution with your intent to continue the charge. Again, this is the last piece of the pie as far as continuing the charge for an additional fiscal year. Looking at the parcel charge, it's being applied under Municipal Water District Water Code 71630. It implies that a municipal water district may impose a maximum charge, $10 per parcel with larger than 1 acre. As also going along with that is Code 171631. So long as the notice of requirements are as existed when the standby charge was initially established were followed. The procedure that we're following here is the procedure that allows for that, where we've applied notices in newspapers within the region, and that was done in accordance with the code. Unless there's any questions on this charge specifically, the recommended action is that the board adopt and authorize the president to sign the resolution number 0617921, a resolution of the Board of Directors of the Central Basin Municipal Water District continuing the standby charge for fiscal year commencing July 1st, 2017, and repealing the previous resolution number 0616901, which was the previous resolution for last year.
Okay, and this is exactly the same. We're not raising anything. This is the same dollar amount we've had for the last 20 years on this whole thing. No increase.
This is the exact same charge since 1991. Yes, sir.
Mr. President, Mr. Chair, I make a motion to approve this item.
If I may, directors, first we still have to give any public agencies, agencies and groups or individuals, and then ask to close the public hearing and then take the vote.
I apologize, directors.
Okay, we have public agencies. Do we have any? We don't. Agencies and groups. Do we have any? We don't. And individuals. We don't. So,
move to close.
Move to closed.
May I have a motion to close the public hearing?
I move that.
Second.
Okay. Director
The hearing
Oscuri?
is now closed.
So there is
Yes.
consensus. Okay. Director Vasquez?
Yes.
Director Grajeda?
Yes.
Director Chacon?
Yes.
Director Gedney?
Yes.
Director Hawkins?
Yes.
Director Aceituno?
Yes.
President Apodaca?
Yes.
Now before you, directors, is the motion. I apologize.
I move to adopt the recommended action.
Second?
Director Oscui?
Yes.
Director Vasquez?
Yes?
Director Grajeda?
Yes.
Director Chacon?
Yes.
Director Gedney?
Yes.
Director Hawkins?
Yes.
Director Aceituno?
Yes.
President Apodaca?
Yes.
Item 10.
I'll be presenting this item as well. Each year, Central Basin establishes charges, and we conclude those with adopting a resolution for our rates for the current fiscal year. The rates were actually approved last year and have already been provided to our customers. This is only the last portion of that is just to commence those charges going forward. We're not actually changing any of the increases that were approved back in, I believe it was October. It was an 8% increase down the line. Unless there's any questions on the charges specifically, the recommended motion is that the board approve, adopt, and authorize the president to sign Resolution 0617922, a resolution of the Board of Directors of Central Basin Municipal Water District relating to water rates and charges for calendar year commencing July 1st, 2017, in Tier 1 and Tier 2 water purchase allowances and continuing each calendar thereafter, and repealing Resolution number 0816908. One thing I do want to mention, this is a requirement for us to apply those charges, though, because it was not in the previous resolution.
So moved?
Second.
Director Oscui?
Yes.
Director Vasquez?
Yes?
Director Grajeda?
Yes.
Director Chacon?
I got a question. Can you repeat what are we doing here on item 10, Albert?
The board approved back in October of last year to increase rates effective July 1st by 8%. The one thing that was not done at that time is the resolution did not include those increases. What we're doing at this point is just completing that process by adopting a resolution.
No.
Director Gedney?
Yes.
Director Hawkins?
Abstain.
Director Aceituno?
Yes.
President Apodaca?
Yes.
Thank you, directors.
Item 11 for the board is the appointment of the board treasurer and deputy treasurer. As you know, we've hired our new director of finance, Rob Gerger, and Dorette Lambie remains our principal accountant. So the recommended action is the board approve Robert Gerger as finance director as the board treasurer and Dorette Lambie, accounting manager, as deputy treasurer, effective as of today, and revoke any prior appointments.
I'll move staff's recommendation.
Second.
Director Oscui?
Yes.
Director Vasquez?
Yes?
Director Grajeda?
Yes.
Director Chacon?
Yes.
Director Gedney? Director Hawkins?
Yes.
Director Aceituno?
Yes.
President Apodaca?
Yes.
Jackie, are you going to handle the next? Sorry. Oh, I'm sorry, it's the Southeast Water Efficiency, okay. Okay.
Good morning, directors. This is my item. It's in relation to partnership with Liberty Utilities for the Southeast Water Efficiency Grant Program. And this is a way for us to save on our fiscal budget for conservation. What we had done was, as we initiated this grant, we invited our purveyors and retail agencies to partner with Central Basin to help with the cost on these retrofits. And so the retail agency that responded was Liberty Utilities, and they were interested in partnering with Central Basin to help with the cost of Hollyfield Park, which is located in the city of Norwalk. The fiscal impact is Central Basin's vendor Valley Soil will be paid by Central Basin for the work completed on publicly owned properties participating in the Prop 84 grant for site work located within Liberty Utilities area. Central Basin will then invoice up to $45,000 for equipment and installation to Liberty. So this saves for this current fiscal year on the conservation budget $45,000. And we're still able to show this work as part of our local cost share on the grant. If there are no questions, the recommended motion is that the board authorize the general manager to enter into an agreement with Liberty Utilities in water use efficiency partnership agreement in the amount of $45,000.
Make a motion, Mr. Chair.
Second?
Roll call, please.
Director Oscui?
Yes.
Director Vasquez?
Yes?
Director Grajeda?
Yes.
Director Chacon?
Okay, I got a question. This money is coming from where?
It's coming from Liberty Utilities.
Okay, everything.
Only $45,000. So for the city of Norwalk, we did a total of 5 sites. The cost was roughly about $137,000. In their service area, Holyfield Park is the only location that's covered with them. And also as part of their PUC requirements, they capped it at $45,000. So it's only for that one location.
What is Central Basin paying for?
We are paying for the audit still for Holyfield Park, along with the other 4 sites.
How much is that costing us?
Our local cost share is $105,000. 45 of that is what's going to be covered by Liberty Utilities. So we're still under, I'm sorry, did somebody say something? Our local cost share is still covered. So before we can tap into the grant, we have to first spend the cost share, which is $105,000. Does that make sense?
So are we getting our money back?
We will, for the cost share, no. That's part of our grant agreement, is that Central Basin also has to pay a certain portion of the project. What we will be able to do is, by exceeding that amount, which we have, there's 200 and, don't quote me on this amount, it's 200 and I think it's $35,000 that we have reserved for phase 1 that we will be able to bill to the grant and get reimbursed for it. It's roughly about $200,000. But by doing this agreement, it saves the district money, because rather than incurring all of the $105,000, we're incurring less because Liberty Utilities is putting in $45,000.
All right. No.
Sandy?
Yes.
Is this budgeted with or without Liberty?
This is budgeted, well, we do have in the conservation budget for this current fiscal year, $135,000.
So even if we didn't have Liberty there, we would have it in the budget?
Yes,
All right,
that's
thank
correct.
Director Getty?
Yes.
Director Hawkins?
Yes.
Director Aceituno?
Yes.
President Apodaca?
Yes.
Thank you.
Directors, item 13 is an extension/new agreement with Upper San Gabriel Municipal Water District for sale of recycled water. We've been selling recycled water at Upper San Gabriel since our first agreement was July 2001, and our contract expires June 30th, 2017. Originally, it was anticipated to sell up to over 1,700 acre-feet, and they had expended capital, we had expended capital, so it included a discount for them of $180 per acre-foot to compensate for the over $3.4 million that the Upper District expended to get it. The demand was never as great as projected, and over the years, only 6,500 acre-feet were sold, so there's a capital credit remaining to Upper District. Last year, Rose Hills began receiving recycled water directly through a federal grant, which drastically reduced the sales there. So the current demand is about to be 40 to 50 acre-feet a year. Upper District requested that we continue this for another 20 years. We'll negotiate it. Although they have capital credits remaining, we have no legal obligation, but we have capital credits remaining too. We negotiated a price which is our full outside service area, which is a $25 increase over the 701 recycled water rate, less a $90 discount. So it's $636. Would adjust annually with our rates, and suggestion was made by Director Oscui in the committee that we have this reviewed every 5 years. That was approved by Upper District. So what we're asking now is approval to continue this contract for 20 years. It will increase our revenues $25,000 to $31,000 a year, roughly. Any questions?
I have a question. So this is gonna be a 20-year agreement?
Yes, ma'am.
Yeah. Is this, I noticed that the previous one was, for many, many years too. Is this common in the industry?
Yes, ma'am. Because they expend capital to build it out, they want to make sure they're going to get the water for a period of time.
Okay. Thank you.
So if there's no questions, then recommended.
Mr. Chair, I move recommended action by staff.
Can I have a second? I'll second. Roll call, please.
Director Osculi?
Yes.
Director Vasquez?
Yes.
Director Grajeda?
Yes.
Director Chacon?
Yes.
Director Gedney?
Yes.
Director Hawkins?
Yes.
Director Aceituno?
Yes.
President Apodaca?
Yes.
Thank you. Okay, so you got this one.
All right, I can still say good morning. Good morning, directors. Today, we'll be discussing the contract with Townsend Public Affairs for grant consulting services. What we're looking at, or we're recommending, is that the item is authorization to introduce contract amount and term extension for contract 2017-3 with Townsend Public Affairs in the amount of $60,000 through June 30th, 2018 for grant consulting services. As the district's grant consultant, Townsend is responsible for assisting the district with research, writing, and advocacy with respect to potential funding opportunities for district projects and programs. Their current focus is seeking funding for Proposition 1, the water bond for the district's recycled water projects. Currently, where we're at in terms of those two projects is we have two general applications before the State Water Resources Control Board. One for the La Mirada project, which we know is on hold until we find out the feasibility of that. The other is the Gateway Cities project, in which we are moving forward on these sub-applications. Just as a matter of information, so when you submit an application, you also have to submit sub-applications for three areas: technical, financial, and environmental. One of the item that you see up before you next is actually going to help support the environmental sub-application. So that's how the process works in the grant application with regards to the State Water Resources Control Board. Extending the contract will allow for the district to continue working with Townsend to complete these applications. To provide some context, Townsend is our current grants consultant. They were selected last year as a formal solicitation process. For your review in the Communications Committee and also in this board packet, we attached the contract for those services in the staff memo. This was a process that was in compliance with the district's procurement policy. The Townsend was selected out of 3 firms. The review of these proposals was independently reviewed. On June 27th, 2016, the board approved a staff recommendation and awarded the contract to Townsend Public Affairs for $60,000 for a 1-year term that is set to expire at the end of this fiscal year. We are recommending a one-time extension, a one-year time extension, and an increase of $60,000 for this contract. And this item was included in the budget that was approved last year. So that's a presentation on this item. Welcome any questions if there are any.
Have we had any issues?
No, in fact, we've been working really well with Townsend. As stated, we're in the process of looking at or completing the application for the Gateway Cities Recycled Water Project. Also, not mentioned but included it also is we also are going to be looking at the federal side of things for funding for our projects as well, such as WaterSmart and the Bureau of Reclamation. So,
I got one question.
Yes,
Why
Director.
have we waited so long to address this issue that they're bringing up before us now? Because I believe this issue that's coming before us now should have been done a long time ago, where we can be out there bringing money to Central Basin to, do projects like this.
So we've actually been working on this for the past year, Director. So I'm confused as to why we're bringing up the renewal for the contract, or
I'm just saying we should have did it a long time ago.
Oh, okay. Certainly. I think we'd all be in agreement with that, Director. Thank you for your comment.
Thank you.
Joseph.
Yes, Director.
Mr. Chair. Has Townsend brought in any money yet?
To date, no. We are in the process of applying for funds for the Gateway Cities project.
Townsend's been working for a year, but they haven't found anything.
So what we've been, no, you're
okay.
Yes.
And the grants that we got through the Gateway Cities was through Gateway Water Management Authority.
Yes. So that was for the planning side. We're looking for funding for the construction side now.
I understand that.
Thank you, Director.
Yeah, we were in Sacramento earlier this year and met with a number of departments, including the Department of Natural Resources Director, and Townsend was there. Actually, they set up the meetings for us, and they were very helpful in identifying the folks that we needed to meet with. In that particular office, we also met with some of the elected officials in Sacramento that didn't know we had applied for some of this funding, and so I thought the meeting was very productive. I think that it's very important for us to figure out a way to finance some of these projects that we have. We kind of sat there, and the staff from the department that we met with pretty much laid out how we could finance the projects. And Townsend was very helpful in that, in getting them to sit down with us. I don't know that our staff could have done it. I don't know that that we have the relationships with those offices. And so I think that, these are very beneficial services to the agency. I think, we need to do something about this recycled water. Thank you to the directors who were here 20 years ago. You all invested in, this recycled water pipeline, which is, I think, almost 85 miles in length. And, we need to just knock on doors now and figure out how we're going to find funding so that we can connect folks. And I think, that's what Townsend is helping us do. So I think we need to have a constant presence in Sacramento. We have the speaker who represents our agency in the state assembly. We have also Kevin De Leon, who has been very supportive of the projects that we have, and I think we need to just stay, in their presence and letting them know what we're looking for funding for, so that we can have some success in this. So I support it, and I look forward to continuing to work. This doesn't happen overnight. I know that Sandy has been very successful in applying for some grant money in the past, and I think this will just be an additional source of potential revenue for us. So, did anyone make a motion?
I'll make that motion.
Okay. Second?
Director Oscui?
Yes.
Director Vasquez?
Yes.
Director Grajeda?
Yes.
Director Chacon?
Yes.
Director Gedney?
Yes.
Director Hawkins?
Yes.
Director Aceituno?
Yes.
President Apodaca?
Yes.
Thank you, directors.
Thank you.
Now it's good afternoon, directors. Mr. President, Mr. Chairman, this item is mine. It's the Gateway Recycled Water Pipeline Extension Project. This has to do with environmental compliance, which Joey just talked about, required for the grant application and the like. All three of the projects and that required initial study and a finding for an mitigated negative declaration. All three projects, those being Bell Gardens, Linwood, and Southgate, required environmental document preparation. These were done by Keith Dunbar and his environmental company under contract to the district. Those items have been prepared. They've been available. They've been available on our website. They've been available here at the district. We provided them to many different public agencies so that they could be reviewed and commented upon. They were commented upon by several agencies, and we've responded to those comments. Those comments for each one of the cities, there's a general comment or a general preamble to each one of them, and that there's a 30-day review period in which we received comments for the environmental documents. Comments
from U.S. Fish and Wildlife Service, the State Clearinghouse, Native American Heritage Commission, Caltrans District 7, Southern California Gas Company. This was true on each and every one of them. They were all three the same, effectively boilerplate, pretty much, because they're all in the Central Basin, and they all found the same environmental effects within our district because they weren't disparate and the like and spread out. The recommended action is that the board now approves the draft initial study, negative declaration for the environmental compliance for the City of Bell Gardens Recycled Water Expansion Pipeline, the City of Linwood Recycled Water Expansion Pipeline, and the City of Southgate Recycled Water Expansion Pipeline. Each of these are listed, and they are in compliance with CEQA.
So go ahead and move staff's recommended action.
I'll second that.
Director Escudi?
Yes.
Director Vasquez?
Yes.
Director Grajeda?
Yes.
Director Chacon?
Yes.
Director Gedney?
Yes.
Director Hawkins?
Yes.
Director Aceituno?
Yes, with the abstention to the City of Bell Gardens portion of it.
President Apodaca?
Yes.
Thank you very much.
Shall I get started? Okay. For item number 16, hello directors. As you're already aware, Liberty Utilities currently holds 2 contract agreements to operate and maintain the district's recycled water distribution system. Both expire on July 15th, 2017. As you're also aware, staff are in the middle of procuring a new contract for these services. The current schedule for the O&M RFP will require a time extension and value increase for Liberty's 2 existing contracts. On Wednesday, May 31st, 2017, district staff met with Liberty, and this was to discuss extending their contracts, and were able to come to an agreement on those terms. Starting with the first contract, which is for the Rio Hondo distribution system, which is for the northern half of the recycled water distribution system. We have on the first slide, you see here a history which shows the original contract and subsequent 3 amendments that have been processed. This information was included in your memo. The first amendment was a change in language for cost controls only. The second was added scope to correct serious problems at the Rio Hondo pump station. And the third was to add scope for recycled water customer connection support. At this time, we are now contract value-wise at a total of $1,315,269 for Rio Hondo. For the contract extension, Liberty Utilities has proposed a reduced monthly cost of $28,613. The extension is for 2.5 months. However, we rounded up to 3 months to calculate additional anticipated costs. The total proposed amount for Rio Hondo is $85,839. Staff have added a 15% contingency, which has been standard practice for this contract, which brings the amount to $98,715. And that would increase the total contract amount to $1,413,984. Next, we have the Century Distribution contract, which is for the southern half of the distribution system. We also have on this slide a history which shows the original contract and subsequent single amendment that has been processed, which was to add scope for recycled water customer connection support, the same as Rio Hondo. This information was also provided in your memo. Okay, thanks. At this time, we are now contract value-wise at a total of $618,708, and this is for the Century system. For the contract extension, Liberty Utilities has proposed a reduced monthly cost of $20,720. Again, we rounded up to 3 months to calculate additional anticipated costs, and the total proposed amount for Century is $62,160. And so we did, as we did for Rio Hondo, we did the same thing for Century, which was to add a 15% contingency, which will bring the amount to $71,484, and that will increase the total contract amount to $690,192. And at this point, does the board have any questions that I may address?
Yes, Jackie. Where are we with the RFP process? When was it issued? Have you received proposals? And when is the evaluation going to be completed?
We have actually received 2 proposals. They were due on June 16th, and I have an item that's on the information calendar that I plan to give a full update a little bit.
We may not cover that, so why don't you just give a quick briefing now?
Okay. So, for the O&M RFP, which is RFP 170, the RFP was posted on May 1st of this year, and so those were due on June 16th. We've received 2 proposals, and that is from Severn Trent and Liberty Utilities. And so currently what we're doing right now is we're in the evaluation process, and we plan to have a recommended motion brought before the board at the July board meeting.
Okay.
I believe we have interviews scheduled this Friday.
This Friday for June 30th, we'll have an interview panel. That is correct.
So we'll be ready definitely before the September extension?
We hope so. Depends on the negotiations go when we select the appropriate firm, but it looks like it'll be a successful process.
Thank you.
I have a question, Mr. Chair. Could you go back a slide? There was something about customer development services.
That's right here, yeah.
What is that?
That's actually, they subcontracted with Joe Walters, and he was brought on board to help train Donald Jones and help us obtain more recycled water connections.
And they also provide some staff support on that. Adam is quite helpful, so.
They definitely do.
That was voted on in 2016.
For both contracts.
It's my belief that our staff is also covering this issue of customer development too, so I'm not sure, I'm trying to get my hands around, are 2 different people doing the same thing?
Actually, no. Well, in one sense, what happened was we did not have any staff capabilities at the time. We had a long debate with the board from November through April, and we came up with the process of hiring an entry-level person and training them, and that's what this contract is. And within a year or 2, they'll be trained to the point where we will need the supplemental support. But right now, it's been very helpful. It's working successfully. We have probably been our best success the last year. We have connections being hooked up every month through the rest of the year and into next year.
I believe they're doing a great job also, right?
Yes, they are. It's been a successful process. One of the things in my time here, the board interaction, whether it was Director Hawkins at Chacon, Director Roybal at the time, Director Vasquez, Director Apodaca, all participated in coming up with the right decision at the right time. It just took some time. It was a good lesson in civics for me.
I understand that part of the work that they're doing is developing kind of the how-to manual so that our staff, can will eventually be trained to do the job.
Well, that's exactly right. And that and together we get some input from Norris Brandt on checklists and that. So we're making it to make the process that we can do it ourselves and go forward with existing staff.
That's excellent. Thank you.
Are there any further questions?
Nope.
Okay. With that said, the recommended motion before the board is that the board authorize the general manager to, number 1, execute Amendment 4 to Contract Agreement 2015-4 with Liberty Utilities for the operation maintenance of the Central Basin Rio Hondo Recycled Water Distribution System for a contract value increase of $85,839 with a 15% contingency of $12,876 for a contract increase of $98,715 for a total not to exceed contract amount of $1,413,984 and for a contract term extension up to September 30th, 2017. And number 2, execute Amendment 2 to Contract Agreement 2016-1 with Liberty Utilities for the operation and maintenance of the Central Basin Century Recycled Water Distribution System for a contract value increase of $62,160 with a 15% contingency of $9,324 for a contract increase of $71,484 for a total not to exceed contract amount of $690,192 and a contract term extension up to September 30th, 2017.
I'll make that motion.
Second?
Director Schooley?
Yes.
Director Vasquez?
Yes.
Director Grajeda?
Yes.
Director Chacon?
Yes.
Director Gedney?
Yes.
Director Hawkins?
Yes.
Director Aceituno?
Yes.
President Apodaca?
Yes.
Thank you very much. Number 17 is also my item. Okay. Hello again, directors. The slide we have for you today will show a portion of the district's recycled water distribution system that this item is specifically addressing. This map and the agreement with SCE for this item is Exhibit A and B. I would like to start by informing you that there is an error in your memo on the slide regarding a specific term used and in your memo, and the error is the term easement, and this is incorrect, and I'd like to bring that to your attention. This agreement is a license agreement. We pay on an annual basis. It's something like paying rent and not a permanent easement which grants rights to the property in question. With that said, I would like to start by describing infrastructure shown on the slide. This section of recycled water pipeline was one of the first projects for the district, and this was constructed in the 1990s. We have different diameters and lengths of pipeline which are delineated on the slide, and that's over towards the bottom right-hand corner for you. We have a range of 6 inches to 24 inches for pipe diameters and nearly 5 miles of pipelines, and this segment is located in the cities of Paramount and Southgate. When the pipeline was constructed, it was placed within a portion of property owned by Southern California Edison, or SCE, and at that time the district entered into an agreement with them. The term of the agreement is for 5 years, and this is for the agreement that's attached as an exhibit, which is the same as the previous agreements, and this will be commencing the 1st of July this year through June 30th of 2022. Invoices are paid on a yearly basis, and payments do include a 3% annual increase. Staff budget for these costs during the budgeting process each year, and costs have already been included in the approved 17-18 fiscal year budget. A table in your memo does show what payments will be made to SCE each year. And so total costs over the 5-year term will be $351,558.61. This item was brought before the special board on May 4th, 2017 as an action item. It was tabled to look into some cost reductions. A conference call did take place on May 30th, and this was to investigate those options. And the conclusions from speaking with SCE is that they are revising all agreements as they expire with the same formula to determine costs. And those 3 items are location, acreage, and land use, and also that an easement may be difficult or expensive to obtain. And so with that said, staff are recommending that we move forward with the agreement as proposed by SCE. And at this time, I will address any questions that the board has. Okay, with that said, the recommended motion to the board is that the board approves, number 1, a new 5-year contract agreement commencing July 1st, 2017 and ending June 30th, 2022 in the amount of $351,558.61 with Southern California Edison. And number 2, authorizes the general manager to make annual payments as shown in Table 1 of your memo to SCE, who will in turn grant permission to operate and maintain the district's existing recycled water distribution system located within SCE's property in the cities of Southgate and Paramount.
Mr. Chair, I move to adopt the motion recommended by staff.
I'll second.
Director Schooley?
Yes.
Director Vasquez?
Yes.
Director Grajeda?
Yes.
Director Chacon?
Yes.
Director Gedney?
Yes.
Director Hawkins?
Yes.
Director Aceituno?
Yes.
President Apodaca?
Yes.
Thank you very much.
Item 18 is the legal billing for May 2017. The board had asked that any legal bill in excess of $25,000 be brought to the board for approval. The bill this month is $40,075. The day-to-day work of the district is a little over $20,000, but the 2 lawsuits that we have outstanding, both of which pertain to the AB 1794, the work on that total a little under $20,000. So we expect both of those extra costs to disappear in the next month or 2, as those cases are wrapped up. So the normal work is about within the budget of $25,000. It's just the 2 lawsuits that cause the overage.
Any questions? Any comments? If not, I will entertain a motion.
Vice Chair, I would like to move the recommended motion by staff, approval of it.
I'll second it, Mr. Vice Chair.
Roll call, please.
Director Schooley?
Yes.
Director Vasquez?
Yes.
Director Grajeda?
Yes.
Director Chacon?
No.
Director Gedney,
Yes.
Director Hawkins,
Abstain.
Director Aceituno,
Yes.
President Apodaca.
The next item is the general manager's goals. In interest of the time, and also a couple of directors have said they did not have enough time to study them, I propose that we put this out for another month. It's director's goals for the year. We've incorporated comments from Director Vasquez and other directors, Director Apodaca, and but again, it's nothing urgent, and the only goal is that we try and do these congruently with our strategic plan that's coming up.
Mr. Vice Chair, the other items remaining are the information calendar for discussion. Is that
Yeah, we're gonna skip all of those unless the director wishes to discuss.
Well, there are some members of the public present at the audience. If they wish to pull any item, I would like to have given the opportunity to do that so we can discuss it and then go to the closed session and pick them up where we left.
Vice President Aceituno, is that okay?
That's fine.
Okay, so we'll defer the general manager's goals to next year, and then if any member of the public is okay, in that case, we will just give the written reports on that to the directors, and we'll brief you on anything else later on.
Vice President, just for clarification, we are tabling the item on the general manager's goals till next month?
Correct.
So now we do have one closed session item that was added just recently, Attorney Felder.
Yes. Pursuant to the finding and vote that the board already made, the board will be meeting in closed session to have a conference with legal counsel regarding litigation of Ronald Belke versus Central Basin Municipal Water District, State of California. Kevin Hunt, General Manager. Goes 1 through 100, Los Angeles Superior Court case number BC 65069. And as usual, we admonish that the Brown Act prohibits the disclosure of confidential information acquired in a closed session by any person present and offers various remedies to address willful breaches of confidentiality. These include injunctive relief, disciplinary action against an employee, and referral of a member of the legislative body to the grand jury. It is incumbent upon all those attending lawful closed sessions to protect the confidentiality of those discussions. Only the legislative body acting as a body may agree to divulge confidential closed session information as regards attorney-client privilege communications. The entire body is the holder of the privilege, and only a majority vote of the entire body can authorize the waiver of the privilege.
And this should take about 15 minutes.
Not even that, hopefully.
We'll now go into closed session.
Closed session, the Board of Directors met to discuss existing litigation, Ronald Belke versus Central Basin Municipal Water District, et cetera, et al., LA Superior Court case number BC 650697. The Board of Directors approved a settlement offer with respect to that lawsuit, the terms of which will be disclosed to anyone upon request once the documents are executed by all parties. All directors were present and the decision was unanimous. Otherwise, on the agenda, General Counsel report, nothing else to report.
General Manager? The district will be closed on July 4th, but open for business on July 3rd. We have a committee meeting that day, and my folks. And also a reminder that at next month's board meeting, we'll be doing the Brown Act and board teamwork training.
No, that was a comment.
No comment, sir.
Yeah, I have a few comments. On the minutes, I remember that we talked about an ad hoc committee regarding recommendation for board compensation. Has the ad hoc committee been set up?
I'm sorry, the ad hoc committee,
The May 4th minutes, talking about an ad hoc committee set up to
for
discuss.
director compensation?
Yeah.
Director Apodaca was going to do that right
Okay.
after the 1st of July.
Okay, thank
fiscal
you.
year.
And then the cyclic storage agreement, what's going on with that?
The cyclic storage agreement is in negotiation. I don't know if Kevin's still here, but in negotiations right now, trying to, WRD was going to take the lead to get all the attorneys together to try and figure out a way around it.
Okay.
And we're working through but on the cyclic tour specifically, it's in WRD's hands to set up the meeting with the attorneys.
Is there an update on the quagga mitigation? What's going on with that?
The only thing new on the quagga is that there has still been no real quagga identified since February with all this scare. All of the tests they've done have never shown that a real quaggas. They are only suspected villigers, as they call it. And there's been a mitigation letter that the county has sent to the upper district, which they also sent it to us to look at, which we have our attorneys and our insurance people looking at to see about mitigating as a way to do it. So we're making progress toward going forward. If there are no quaggas and the county still wants a mitigation, then it comes down to what is the possible risk to the district and what do our insurance people say about it and that. So we're working through that process now. Hopefully next month we'll have some detail. It's going to take about 2 months to wrap this up.
Can the board see that letter?
What?
Can the board see that letter about mitigation from the county?
Yeah, absolutely.
Okay,
Yeah.
you can send that out?
Yeah.
Okay, and then the last thing, I have a problem when someone that does work doesn't get paid for the work. And we have an attorney that comes here and works for this district. And you have one director that's denying payment of that attorney for his work. If that's the case, then going forward, I cannot approve any more per diems to Director Chacon for the work he's doing, because he's doing that to our attorney. So going forward, you have one director that's denying payment for per diems for Director Chacon for the work he's doing because of his denial to our attorneys, even to attend these meetings and do this work. Thank you.
And I might tell both Directors Hawkins, Director Chacon and Director Grajeda, this is the type of thing we'll be discussing after the Brown Act next week, ways to address these type of issues so that we can deal with the differences of opinion in a more civil manner.
I appreciate that, but my statements need to be on the record.
I understand.
I'm sorry, Mr. Chair, are we on item 33 or 32? Are we taking both at the same time?
We're on either, we were not on 30.
Well, 30.
I didn't even realize we had 30, the one on the conferences.
So why don't we just combine it? If anyone has attended any conferences, they can make a report as part of item 33 then, please.
I attended the NALEO conference. I actually took notes. I don't have them with me, so I'll go ahead and put those in the record at the next meeting. Mm-hmm.
Any other? No? Anyone else?
I also attended ICA in June and also CCA in May. So just for the record. Also, I asked Director if he wanted to bring it up in closed session, the matter he just brought up. I would be more than willing to discuss it with him. And I have my reasons why I do not vote for Nassim Billing. So that's it. I'll leave it at that.
Those discussions cannot happen in a closed session meeting.
But any two directors are welcome to sit down, the two of them.
Of course, but it's not a closed session matter.
Okay, so should I bring it up in public?
Yes.
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 As part of your comments when we get to you.
What's that?
I said, I'm sorry, Director, it is your turn or is it Vice Chair Aceituno's turn to do the public comment? Because we can take your report as part of your comments that you're going to make.
No, I'm just, I asked Director if he wanted to bring it up. I would discuss it with him in closed session. So, I don't want to say anything wrong about the attorneys, but I'd rather discuss it in there.
But it is not a matter that can be discussed in a closed session setting. Regretfully, that's a law.
Okay. Well, I can vote and support attorneys that were representing the opposition during this legislation. So I'll leave it at that.
I'd like to report out that in May, I went to the Contract Cities event.
I have nothing to report. Meeting's adjourned.
Thank you.
Thank you.